Right, I think we'll get started now. Hopefully, our sponsor for the session, Finders International, will join us at some point, and they may give just a brief presentation towards the end of the session. In the meantime, if I could just draw your attention to some other forthcoming Surrey Law Society training that's taking place in June. We've got a webinar with June Ventners on recognising coercive control on the 6th of June. We have our annual Past Presidents Championship Cup at Daytona on the 20th of June. So it'd be great to see some of you there. And then towards the end of the month on the 26th, we've got an online course, a residential conveyancing update with David Keithley. You can find details of those sessions and any future sessions. We have got some happening in July too at surreylawsociety.org.uk. So thank you for joining us today. Thank you, Jane, as well, for delivering this session for us. If you'd like to ask a question of Jane, you can type these into the Q&A box or the chat facility during the webinar, and then Jane will hopefully pick these up towards the end. If you'd like to ask a question directly towards the end, I actually think that you are able to unmute yourself, but if not, you want to raise your hand and we'll unmute you and you can talk to Jane directly. The webinar is being recorded, and you will be sent that recording after the session. We'll also send you a feedback form and be really grateful if you could complete that for us. It does really help in kind of preparing our programme for next year. So with no further ado, thank you to Finders for sponsoring. We hope that you're able to join us shortly, and thank you so much to Jane for delivering this session.
Great, thank you very much. I'll just share my screen.
Oh, I'm so sorry. Louise, hello. Just in the nick of
I am
time.
so sorry. I really do apologise for my lateness. I have no good excuse. I'm so sorry about that.
No problem. Louise, are you okay just to do a brief intro? Sorry,
Absolutely.
I'm so sorry, Jane.
It's absolutely fine. Welcome, Louise. Don't worry
Hello
at all.
there. I really do apologise to everybody. I'm very sorry about that. I'll make this extremely quick. I'm just going to give you a very short, very quick refresher and reminder about what it is that Finders does. And Jane, I do apologise again for making you stop. So Finders is probably best known as a genealogist. We're a people tracer. We are brought in by practitioners, estates and banks and trusts to primarily help locate people, reconstruct family trees, verify family trees is something we're being asked to do more and more. And that I think is the work that we're best known for, but we do have a wide range of other services as well. So, one scenario might be that there's an intestacy with perhaps a partial tree that's been produced. There is some information, but some is lacking, missing. And in that situation, we can step in and resolve whatever uncertainties there are. And we are increasingly passive as part of due diligence, being asked to verify family trees. So there may be no surprises there. The information might be all pretty good. You're pretty sure that everything is as it should be, but we do know from quite a number of horror stories that we do tend to see at this end of things that it isn't always the case that everybody does know, and it isn't always the case that everybody is truthful. There are, one or two particularly horrendous stories where people are actively lying and withholding the truth. That is unusual. It's much more likely that in any really big family, perhaps one branch or stem of the family has become lost or contacts dissipated. The typical scenario is that the good keepers of the well-kept address books, the ladies in the family, tend to pass away, and those linchpins go, and then suddenly things tend to fall apart a bit, and the more distant cousins, maybe contact is lost with those. So whatever the scenario, we can step in, whether it's one person or an entire family, or for that matter, an entire intestacy, resolve the position, conduct the research to make sure that everything's as we think it should be. And off the back of that, we have a long association with the insurer Aviva, and we can therefore get missing beneficiary insurance or missing comfort policies over the estate as a whole, and make sure that everything possible has been done, that due diligence has been met, so that the estate distribution can carry on. Now, beyond that, we also have other services, including our legal support services team. They do things like searching for bankrupt beneficiaries overseas. So you're at the point of an interim or final distribution, and you're wanting to make sure that you haven't got someone living overseas who in fact is bankrupt or insolvent. And we do checks like that day in, day out. So we make life an awful lot easier for the person who otherwise has to do an awful lot of Googling to resolve that. We have a will search service, which is very much an old school product. That means that we are writing to local firms. We can advertise in newspapers if required. It's a fixed price product. And again, off the back of that, we can get missing will indemnity insurance as part of that brief to indemnify the estate as a whole and make sure that there aren't going to be any nasty surprises later, or for that matter, that the will that everybody was certain existed definitely cannot be found. We also do missing asset services and asset search services. So, for example, in the United Kingdom, that includes dormant as well as live assets, and is proving extremely useful as a sweep to make sure that everything possible has been done to identify assets. Overseas, the picture is a bit more complicated, but and this is generally true of everything at Finders, we always encourage you to make contact with us. If there's anything that we can do to make sure that, any advice that we can give, even if it isn't an actual service that we can provide, we're always happy to do that. Very, very briefly, the team that I head up is called the International Asset Services team, and that includes things like shares held overseas, bank accounts overseas. We are often asked by estate practitioners to help because it can be an enormously frustrating and time-consuming part of the wider estate administration work. We deal with things like this all the time, and of those assets, the ones that come up the most often would be shares in America and bank account and investment accounts in America. I can see Jane nodding there. This comes up a lot, and I think it's partly, at least, because it's so counterintuitively frustrating and difficult to deal with some of these foreign institutions. They most definitely will not be willing to part with information, let alone assets, easily, as some institutions in the UK have become quite famous for doing. I've been hearing recently, for example, that UK banks are giving out quite large sums of money, many tens of thousands, on production of a death certificate. And I can comfortably tell you that's never going to happen in a US bank or any other foreign bank for that matter. In fact, usually production of the death certificate just about gets things started, sort of 0.1% of the way through that process. There will be a great deal of additional bureaucracy and compliance, and it's something that we're used to doing. We do this pretty much day in, day out here. So whenever you have situations like that that might benefit from an initial conversation without obligation, you're always welcome to contact us and we can discuss how we might help. And if we can't, we'll always be willing to try to provide as much advice as we possibly can to get you on your way. I have definitely spoken for long enough, especially being so late. My apologies to everybody, but I hope that you'll enjoy the event, and Finders is a very proud sponsor of STEP, so I really hope that you have a good session. And thanks again, Jane. My apologies for breaking into your talk. Thank you.
No apology needed at all, Louise. All I had done was said my name, so you're absolutely fine. I was actually trying to figure out how to share my screen, so you helped me out. Here we go. Okay. Well, hello everyone. I'm delighted to have the opportunity to present to you today. My name is Jane Whitfield and I head up the private client team here at Elite Law. So here's an overview. There we go. Here's an overview of what we're going to cover in the session today. And it's all to do with delays, either at the probate registry end or at our end, and how you can best use the time whilst you're waiting for the grant of probate to come. There's some tips I can give you to what you can be cracking on with in the meantime. So before we, oh no, what's gone wrong now? Here we go. I thought before we look at what things that you can do while we're waiting for the grant to come back from the probate registry, I thought it might be quite useful first to look at why there are delays and what sorts of things we can do as practitioners that can hold things up at the probate registry at their end. So at their end, it's still taking about 16 weeks for probate to come if you're doing an online probate application. If you have to use paper, then forget it. You're probably looking at 8 to 12 months, and that's certainly been my experience. If you're having to apply by paper hard copy, that's usually because you're applying for an attorney grant or for a second grant in the same estate. if you've got a foreign will or the person who died was non-dom, you're resealing a will under the Colonial Probates Acts, or you're applying for letters of administration with will annexed and there's a life interest in the will. Those seem to be the common things why we need to send in a paper application. And as I say, they're taking 8 to 12 months at the moment. They have said that they are trying to reduce that time, but I have to say I haven't seen that myself yet. And if you have a query and you want to ring the probate registry, they have revised operating hours. You've probably been experiencing that yourself. Back in February, they changed their opening hours, so it's now 9 AM to 1 PM, Monday to Friday. And in their recent release, they said, following a successful trial period. Well, I'm not sure if that's their success. Doesn't feel like a success from here because you can't speak to anybody in the afternoon, but they feel that's been a success at their end. So they are going to be continuing with those hours indefinitely. They have said they will review the arrangements every 6 weeks. They've also said that professional applicants can continue to contact the probate service via the web chat, and that is available in the afternoons. I don't know if you've tried using the web chat. I haven't had a hugely successful experience of getting a sensible answer via the web chat, but it is available. So the other problem with delays is when an application gets stopped at the probate registry end, and they have issued some guidance to practitioners about how to minimise these. And the ones that you can see on the screen, those are the most common things that make an application become stopped. So missing documents, that could be a power of attorney or a deed of renunciation, something like that. Missing executors, that often happens if an executor has died and you don't fill out the space to say why you've missed them off the proving executors. There is a white space in the online application to say what's happened to all of the executors, and you're now prompted to say if all of the executors have been added. Also, the condition of the will. Now, this is quite interesting because they listed the things that they look for, and it includes staple holes and paper mark clips. We'd expect that, but they also look for rips and stains. So whatever you do, don't spill your coffee on the original will, because you might then have to do a statement saying why it's stained. And there are text boxes in the online application too, if there are anything like staple holes or that on the will, you can put that in the white space. And the information that you put in that space that then goes on to the legal statement, and that is reviewed by the people who are assessing the application at the probate end. So that's delays at their end. These are now going on to some of the things that you can be getting on with once you've put the application in. And closure forms is an obvious one. So if you've got 16 weeks to wait, you could crack on with getting banking building society accounts forms filled in. It's the perfect time to get them signed by the PRs. Nearly all of the assets the deceased has will have some kind of form to fill in to close it off or to transfer it. I usually ask the PRs to sign all the forms they need to, send them back to me without a date on them. Once the grant comes through, just in case there's any unusual delays with the grant, we can then put the date on the form once we've got the grant, and we can send everything out together. Bank accounts, national savings and investments, that's usually just the one closure form. They have often sent out, if like me, your probate letters say, give us the date of death, balance, and also, by the way, please send us any closure forms. You may well already have the blank versions on your file, so you can just get filling those out in the time. Investment accounts may have broker specific sale forms if you're selling investments. If beneficiaries want to receive investments in specie, then a lot of the brokers now require them to go onto their books as a client in their own right. And so they will have all of the usual compliance and ID procedures to go through with the beneficiary. If there are individual shareholdings in the estate, then you have my deepest sympathies, particularly if they're certificated and you have to run around trying to find original share certificates. I'm sure that's something Louise's team have a lot of experience in trying to find certificates. You can get an indemnity for a lost share certificate, but you do need to have a complete set if you want to sell them. The PRs can sign a share sale form, which I've had to practice saying, share sale form. If the shares are held electronically, it's a bit easier. You don't have to hunt around for share certificates, and you can just then get the PRs to sign a share sale form. It's like a prepaid plan. You need good teeth. I've put pension plans in there because sometimes pension providers, I've just done it recently with a teacher's pension, where they have a surviving spouse, a widow's or a widower's pension that they then continue to pay. Great long form that the surviving spouse has to fill in to claim the widow's pension. And sometimes they want the PRs to sign that form as well. So if you do have a pension form, that's something else that you can be getting on with while you're waiting for probate. Vehicles and chattels, again, this period of time, it's a good time to sort out if the deceased had a vehicle, what you're going to do with it, get the forms from DVLA. Once the chattels have been valued, you could consider passing on chattels that are in a specific gift, if there's a will, to name the beneficiaries depending on their value. That's a judgment call that you can take at the time, really, but it's something that you could consider. If there are works of art or collectibles in the deceased's property, you should really consider whether they're worth going to auction. If so, then auctioneers such as Bonhams and Sotheby's will arrange to collect any items, and they will keep them in safe custody at the auction house ready for sale. So they just come out of an empty property and going into something that's a bit more secure. The only thing to watch though, and I've got it on one of my probates right now, is that if items go to auction before you get the grant, they won't give you the proceeds of sale. They'll sit on them until they have sight of the grant, and then you can tell them where you want the money sent. They may ask for proof of authenticity if you have unusual items in the estate, and some items may need to be sold in a specialised auction or sales service. So again, those are conversations that you can have prior to receiving the grant. And then the final point on that slide is if the deceased owned their own business, it may be sensible to collate detailed plans if it's going to be sold or dissolved, either in part or in whole. And that could involve agreements on valuation. So you should start having conversations with the deceased accountants to discuss potential buyers, terms of sale, valuation methods, things like that. But a bit of sensitivity is needed here commercially, obviously, because if the business owner has died and it's going to be sold, that may have an effect on the value if word is spread very quickly that the business is about to be sold. And then if there's a property in the estate, you should start thinking about whether it's going to be sold. It's worth shopping around, talking to a number of different estate agents. Sales commission can often be negotiated, so it's good to shop around. Find out what the agents will need to list the property and their requirements for accepting offers and things like that. Also get their take on when would be a good time to sell the property, because they'll have a handle on the market conditions at the time. You will then need to agree with the PRs how viewings will take place and who the key holders should be. And there's an agent called the estates agent who work with finders, and they manage and sell property specifically for PRs. So it's worth having a look at what they do. They're specialists, as I say, for deceased property, so they get what it's like for executors and PRs. You do need to have a think about timings for the property sale. I'm sure you'll all know you can't complete a sale before you get the grant, but you can consider marketing the property once you've submitted the application for probate, and you can talk to the agents and work out your marketing strategies. You will need to coordinate that obviously with the PRs and the beneficiaries of the estate. If the property is very cluttered, then I would say now is the time to try and declutter a bit ahead of marketing the property, certainly before the agents send the photographer around. The general view, and it's one I share, is that a property will sell better if it's got something in it, if it's furnished to a certain degree. So it's not completely empty, but it's not full of the deceased personal things like photographs and knickknacks either. So there's a balanced middle ground there. Common sense should prevail. If the property is tenanted, for example, if the deceased had gone into a care home and the property had been rented out rather than sold, then you'll need to liaise with the PRs about when to serve notice on the tenants for them to vacate the property if you're selling with vacant possession, agreeing with the tenants how prospective purchasers are going to view the property, because obviously they'll be coming in and out of where they're living. It's really important to look at insurance. The normal insurers, normal buildings insurance won't cover unoccupied properties, as you probably know. And without it, if the pipes burst, then you'll be filling in a claim with your PI insurers. So again, the estates agent are one of the agencies who do unoccupied property insurance. There are other providers such as Howden and Lawshore and others. So again, it's good to shop around. Okay, statutory notices. My first point says why they matter. It's the PR's responsibility to handle any claims from creditors against the deceased estate whilst protecting themselves from any unknown liabilities. So placing those statutory notices ensure that you can show that enough effort has been made to locate creditors before you distribute an estate. And that also protects the PRs from being liable for any unidentified creditors. If you don't do the statutory notices and a creditor comes forward after the estate has been distributed, then the PRs could be held personally liable for those unidentified debts. The statutory notices are normally placed once the grant is issued, and it's placed in the Gazette and a local newspaper closest to where the deceased lived, and that will allow time for any potential creditors to come forward within the established notice period, which is a minimum of 2 months. So it'll be 2 months from when the grant is issued. That also then provides statutory protection for the PRs under the Trustee Act 1925. Again, it's something that Louise and her team can do at Finders International. They can place those statutory notices for you. And there's other agencies like Legal Ads and 1 or 2 others. So the period between the grant application and obtaining probate is a good time to shop around to see who can do this for you at the right price in the right area. You can do it yourself, but you would need to source the most appropriate local newspaper and find out what they charge to enter the statutory notices. You may find that the charges that the agencies charge you aren't much more than doing it yourself, and it'll save an awful lot of faff in my experience. If you don't want to, or the clients won't allow you to place the statutory notices, then Finders can provide early distribution insurance, which offers the same statutory protection. So it allows the PRs to forego the 2-month period, where it's 2 months and a day, and enables you to distribute the estate funds earlier. So that is an option. So Louise has already mentioned intestacy. If you are dealing with an intestacy, you will need to put together a family tree of some sort and work out who the relatives are that are going to inherit the estate. As Louise has already mentioned, Finders International can verify the family tree for you prior to you distributing any funds. And I think this is quite an important step for PRs to mitigate the potential risks of an incorrect distribution. Errors can occur for loads of different reasons. You may be relying on one family member to get the information about the family. There are family secrets, goodness me, surely not. Family secrets and mistaken testimony from family members, it does happen. And also, if you rely on internet-based sources, they're not always 100% correct. So there's a risk in putting all your reliance on stuff you can find out on the internet. And the family can give you the wrong details. They omit things, there's a branch of the family that they don't know about or they've forgotten about. So I would say it's usually a good idea to get the family tree verified, unless the family is very small and you're really sure that you've got everybody, that you've got all the correct details. Again, something else that Louise has mentioned is missing beneficiaries and missing beneficiary insurance. Actually, if you're looking at missing beneficiary insurance, then having the family tree verified is one of the things that Aviva insist on having before they will give you a policy for missing beneficiary insurance. As Louise has mentioned, her team can find people both within the UK and internationally. They can do it remarkably quickly with the smallest of information, and they can trace beneficiaries all over the world. So even where you think you haven't got anybody, you think it's all going to go to the Treasury, finders and other tracing agents can find family members quickly, and it's usually at their own expense, but that's a conversation that you can have with them. There are often living family members somewhere, even if they're distantly related, they're living abroad, they've never even heard of the deceased. But if they're there and they're family members, they're still legitimate beneficiaries. So again, it's an exercise worth doing. If you haven't got an intestacy, you may still need to trace beneficiaries. Sometimes they're named in a will, there's no address, you can't locate them. Somebody had an email address somewhere, it bounces back and you don't know where they are. And again, finders and other agencies can trace those beneficiaries for you, even if they've moved abroad. And they can also obtain missing documents. Now, this is something that I've discovered quite recently. And if you need birth death certificates, wills, even decrees absolute, they can find those documents for you and let you have appropriate copies. If you're not sure that you've recorded all of the deceased assets, you could ask finders or another agency to do an asset search. We have a duty as practitioners to inform PRs about identifying assets and also the potential consequences of inaccurate IHT forms, particularly now there's a new penalty regime in relation to IHT. It can take a couple of months or so to complete an asset search. So this period between the application and the grant is a good time to be looking at that if you think you might have missing assets. If you have a file with missing heirs or stems of a family tree, and despite the best efforts of a genealogist to trace their present whereabouts, or research has research has proved inconclusive, you can get insurance cover against those shares of the estate where you can't find the beneficiaries. Once a missing beneficiary insurance policy is in place, the beneficiaries that you have been able to trace can receive their inheritance safe in the knowledge that they won't have to be asked to be repaid any funds in the future. It's never a good thing when you have to go back to beneficiaries and say, can I have some money back, please? I've put disputes in here. I'm not going to spend a long time on disputes. I'm not a contentious practitioner, but they are things that can hold things up once you've put the probate application in. If a caveat has been entered against the estate, then proceedings are halted completely until the issue is resolved. So addressing such issues early, anticipating them, can help get a resolution and can prevent prolonged disputes. Being prepared for disputes over maybe the interpretation of the will or challenges to the will's validity, and those are the two main ones, either a lack of capacity or undue influence. Being prepared for those means that the PRs and the legal professionals can handle cases more efficiently. And this involves having clear evidence and documentation ready to support the rule's provisions or to defend against challenges. This means you often have to be ready to have a Lark and Nugas request land in your inbox. Efficient case management leads directly to minimising delays in obtaining the grant of probate, and also educating PRs and beneficiaries about the potential for disputes and the consequences, court proceedings and the time that takes and the cost, of course. All of those can help mitigate the risk of a probate matter becoming contentious in the first place. Also, 1975 Act claims knowledge of how to deal with those can ensure that parties are better prepared to address the claim swiftly and fairly, and that can reduce the likelihood of extended legal battles. All that happens is that estate resources are tied up forever, and it delays distributions as well. So if you think you might have one of those on the horizons, it's a good idea to start having those conversations with the PRs early on. By understanding the common causes of disputes and obviously their impact on the probate timeline, we can then allocate resources more effectively. This might mean bringing on expert advice early on, for example, seeking a counsel's opinion and ensuring that thorough checks are done to confirm that the will is valid. That will all help to streamline the process and reduce delay. Doesn't always work. If you're going to have a 75 Act claim, it'll come, but being ready for it can help. So appropriation, this is also really important to think about. Once you've put the grant application in, while you're waiting for the grant, you could think about whether it's appropriate to transfer assets to a beneficiary in specie. That's what appropriation is. The PRs may be given a power to appropriate assets in the will, but a general power arises under Section 41 of the Administrations of Estates Act 1925. And this power can be used either in full or in partial satisfaction of a legacy, provided the PRs consider that it's just and reasonable. You can't appropriate assets which have been specifically given to someone else in the will, but it is particularly useful where it is necessary to realise assets such as stocks and shares or property, where those assets are showing a substantial capital gain. In those cases, it can be advantageous to make use of the individual beneficiaries' annual exemptions for CGT, particularly if the appropriation is to more than one beneficiary. Obviously, then you've got more than one annual exemption. If the PRs then sell assets that have been appropriated, they're selling them as agent for the beneficiary, so the CGT falls on the beneficiary then and not on the estate. Important to note, once assets have been appropriated, they're no longer available to meet any debts of the estate, and the beneficiaries will then take the benefit of any increase in the value after the appropriation. So before you go ahead with any appropriations, you need to be really sure that you won't need to have recourse to those assets then to meet any of the debts. I've put charity beneficiaries on there as well. Obviously, charities don't pay CGT, so they will often approach you and ask about appropriation early on. If there are assets to be sold at a gain, it's really important to appropriate those over to the charity first and then sell them as agent for the charity, because then there won't be any CGT to pay at all. As I say, the charities may well approach you before you approach them and ask about appropriation. The other thing to think about in this period of time is deeds of variation. You don't need to wait for probate if you have beneficiaries that want to vary their inheritance. Obviously, you know about the reading back provisions there. You've got the 2-year period from the date of death to do that. The PRs don't necessarily need to be a party. They definitely do if the variation increases the IHT liability. I have to say that doesn't happen very often at all. It's mostly the other way. Having said that, I do often ask my PRs to be parties to a deed of variation, simply because it then makes it more complete. It saves any discussion and any challenges at a later date. But as I say, it's not compulsory unless there's an increase in the tax liability. I've also put a practical thing in on who pays. Before embarking on a deed of variation, it would be a good idea for you to establish who was going to pay the costs, the legal costs for that, the cost for preparing and dealing with the document itself. I would say my rule of thumb is if it's an individual and they want to vary their inheritance, perhaps in favour of their own children, for example, then I would normally ask them to settle my costs for that work, or maybe it could come out of their share of the estate rather than the estate generally. On the other hand, if the beneficiaries are agreeing to a general variation, for example, to vary the intestacy rules, or maybe to agree to give 10% to charity to benefit from the lower rate of IHT, I would usually expect those costs to come out of the estate and be recorded as an expense in the estate accounts. Talking of estate accounts, everybody's favourite topic. I know it might seem a bit odd to start talking about estate accounts during the period when you're waiting for the grant to arrive. But actually, I found if you put the framework together now, it will save you time later on in the administration of the estate. I usually prepare a schedule of assets and liabilities early on in a probate matter, which I fill in as I get responses from the standard probate letters. I call mine an estate summary, but it's essentially just a list of the assets and liabilities in the estate at the date of death. When I filled it in, then I use that information to fill up the IHT forms if it's a taxable estate. As I say, whilst I'm waiting for probate, I usually try and get the estate accounts underway, and I use the estate summary as the initial assets and liabilities schedules for the accounts. You may have already had some stuff paid into your client account, for example, subscription refunds or a credit balance from one of the utility companies. Sometimes little bits come in before you get the grant, and you can include those in the beginnings of your estate accounts. You may well have paid out expenses such as the probate court fees, statutory notices or property insurance, and again you can start putting those on the liabilities section. If I've got a taxable estate, I do often put in a separate IHT schedule. So if you've paid inheritance tax when you put in the probate application, again, you can start filling out that IHT schedule in your accounts. So, well, that's my IHT schedule. I'll bring things to a conclusion now to give us time for questions. It may seem like you've got a long time to wait before the grant of probate lands on your desk, but actually, if you've seen, there's quite a lot you can be doing to make best use of the time, from closure forms to tracing beneficiaries or assets, deeds of appropriation, deeds of variation, even starting a set of estate accounts. I recognise that some of this is probably a counsel of perfection, but I think being ahead of the game, or at least planning and being organised, will mean you're doing your best for your clients. It will also stand you out from your competitors, as well as increasing your chances of getting a great Google review. There we go. That's the end of the presentation bit. And I have stopped sharing. I'll open it up if anybody has any questions.
Thank you, Jane. If anyone's got any questions, you can jot them down in the Q&A box, or you can raise your hand and we can unmute you and you can speak directly to Jane or Louise.
I must have been talking more quickly in the presentation because when I rehearsed it last night, it went on longer. Oh, thank you, Alice. Yes, that's a really good question. The HMRC, so if you've got a taxable estate, I'm sure you will realise now there's a new system with HMRC. So they now send you, instead of doing a 421, which you then send to the probate registry, they send you a letter with a unique code in it. And when you do the online probate application, you can't submit it until you've put this unique code in. HMRC say they take 20 working days to send the letter, and that's roughly about the time I've only had a couple actually since the new system, and it has been, yeah, it's about 4 weeks. I'm certainly saying to clients, don't expect anything for at least 4 weeks. So yeah, so it's 4 weeks to get your code and then 4 months to get the probate. So it can be, that can extend the time before probate comes for sure. Thank you. Yeah, it's a good question. They have changed that when HMRC first started issuing the letter with the code, the online probate application was asking for the code first, so you couldn't go through the application and fill in all the bits that you needed to fill in. It stopped you right at the beginning, but I have noticed that they've changed that now, and you can now populate the application in draft and then fill the code in at the end, which is a good amendment. There was something I was going to ask Louise, actually. It was something that I found in my searches for.
Jane, we've had another question just come in from Brian.
Oh, thanks.
I wouldn't put in Trustee Act ads if the deceased property is unoccupied, even if we had got a grant, as once the ads attracted the interest of burglars. Your view?
Louise, do you want to field that one?
Hello there. Yes, I'm sorry, I'm just reading and digesting this myself. So the ads attracted the interest of burglars. That is a very interesting point. I might have to defer to my colleagues at the estates agent to comment on this further. Can I get back to you about that? I'm going to put that point and just going to quickly scribble it down and maybe circulate afterwards any answers I get to that one, because that is a very interesting point. You certainly don't want to attract the interest of burglars. So yeah, I haven't got any sense whatsoever for myself.
Most of the time, the deceased property would be unoccupied unless family is living there or it's tenanted. So I'm not sure that there's an easy way around.
Yes, the only thing it did occur to me to mention is that, for example, it's possible to, of course, do securing as well as clearing and insuring, and that is certainly something that the estate agents is able to do. So it's possible that perhaps an enhanced security regime in place to make absolutely sure that everything possible is being done, to protect against that kind of risk. But that's an interesting point, and I'll be sure to pass it on. If I do get any feedback, I'll circulate it perhaps via Surrey.
Thank you. Louise has put a different Louise has put on a comment. You can't run the legal statement and circulate for signature until you have the code. That's absolutely right. Yeah, so you can populate the application so far, and then you have to wait for the code, and then you can print the legal statement. That's absolutely right. Yes. Oh, I've just remembered what I was going to ask Louise. When you do international bankruptcy searches, do you also look at IVAs and insolvency situations?
Yes. So very broadly speaking, not every country has an exact bankruptcy arrangement in the same way that England and Wales does. So we would look at whatever the typical arrangement is in that particular country or territory, and then we would do whatever search is feasible. In the very few places where something isn't feasible, or where there's perhaps a grey area or a question mark, we can come back and consult on that and say, well, look, this is what is or isn't possible, and what would you like to do? And is it actually important or necessary for you to do whatever enhanced search might be necessary? Beyond bankruptcy and insolvency, there is a lot that can be done, but it ends up costing a great deal. So that might be a conversation to have on a case-by-case basis. But by and large, yes, it's either going to be a bankruptcy or insolvency, unless that jurisdiction allows for both.
Okay, it's not something I'd considered. I noticed that it was something amongst the services that you provided, and I hadn't really thought about looking for insolvency situations for beneficiaries. But presumably, if a beneficiary was in a voluntary arrangement, then that would affect our ability to distribute monies from an estate and inheritance. I mean, I know about bankruptcy because the funds go to the trustee in bankruptcy. I'm not so sure on where our liability lies if we distribute estate funds to a beneficiary who is in a voluntary arrangement?
No, I have to say I'm not either. And I'm also not sure whether there are many other countries that even do arrangements in quite the same way that they do here with the voluntary arrangement. Sure. What tends to be searchable tends to be court records. So this would be something that someone had to go to court over, and therefore there would have to be some kind of equivalent of trustee in bankruptcy. That's another point I can put to my colleagues in our legal support services division and see if they've got any more comments and views about that. It's worth asking.
Yeah, giving you all the work. I have to say I've not considered what the PR's position would be if we distributed to somebody who was in a voluntary arrangement, whether that is then incumbent on them to tell their insolvency practitioner, or whether we need to notify them as either as solicitors or as PRs.
I'll look into that as well, and we'll see if we can come up with some clear answers. Yes, me too. Okay, something more.
Jenny, let me see if I can unmute you, Jenny. Helen, you may need to do that.
Jenny, yeah, Jenny, I've allowed your mic so you can hopefully unmute yourself now and speak. Are you there, Jenny?
Wonderful technology.
I know. If you want to raise your hand again, Jenny, just if you, yeah, there you go. So your microphone is, and your camera should be enabled now. So at the top right hand corner, you should see the microphone, and you can just unclick that, and that should unmute yourself. Alternatively, if you want to just pop your question in the chat or Q&A box, then I'm not sure quite why we can't hear you. Just wait for that to come in.
Sure.
In the meantime, if there are any other questions, if you could type them in or raise your hand, that would be great.
Louise, have you got anything particularly quirky or a particular triumph that you're proud of?
That's a good one. There's always quirky things. I think we do say, it's safe to say we do dwell in the land of quirk and where things don't go quite well. I mean, there's a particular sort of horror story in terms of beneficiaries and you know, declarations of who the family is or isn't. The worst one that we've come across in recent years is a £400,000 estate, where the lady says she's the sole heir to her late brother's large estate. And it turns out verification is done and she isn't. It didn't take very long to find this, incidentally. She simply withheld some information. Turns out there was another brother who had died, leaving a son. So there's a nephew in the picture who is entitled to half the estate. And when she was questioned about why she'd withheld this information, it turns out she had disowned him because she disapproved of his lifestyle. I think he'd been in trouble, possibly in prison at some point. So clearly that was a reason for excluding him. So he was entitled to benefit and did indeed benefit. But I think it's, you know, it's one of those signs where sort of reading the picture, you know, what do you know about this person? Do you know them really well enough to feel sure that their testimony is accurate? It's not a question of, you know, disbelieving everybody, but maybe taking a view. And we often talk to practitioner firms about this. You know, do you have a kind of internal threshold above which you perhaps take a closer look as a matter of, you know, normal routine to say above a certain value of distribution, or perhaps even a few enough number of heirs? You know, do you then say we need to be really careful and that we've done everything we can? These are very, very rare. In my own past, previously as a probate genealogist, I came across a family. I think there were 4 siblings, spoke to them all. Then it turned out there was a fifth. Went back to the original people who said that there were four, saying, is there some reason why you didn't mention this? And I think the answer was, well, I didn't think you meant her. Clearly, they'd had some falling out and didn't feel it was necessary to mention the fifth sibling, who did indeed live and was indeed entitled. So these things come up, but it wouldn't be fair to say every estate deserves the same amount of scrutiny. And I think more recently, in terms of my current existence as an asset specialist, it's really about the disconnect between expectation and reality when it comes to dealing with overseas assets. You're often talking about months, you're usually talking about years. If, for example, you have high value assets in the US, there's a federal estate tax exemption threshold for non-US citizens of only $60,000. So it's actually very likely that any even remotely high value US estate is going to need this tax clearance process. And bearing in mind what you were saying about HMRC probate delays, that tax clearance is taking 2 years on average. In reality, it's taking longer than that. So 2 years for estate tax clearance. And this is often something people are finding after they've been through the rigmarole of dealing with the asset holding institutions. Some banks, they'll take months to decide that you need this thing, whether or not the federal state says that you do. You then still need it. That's 2 more years on top of what could have been a year's worth of effort trying to close an account. So, we're finding things like this, sort of nasty surprises do lurk everywhere, and as far as possible, trying to help be on top of them. So I'm going to stop talking now because I think there might be another point or query.
I've just seen a couple of questions. So Jenny said, did you say that Finders International provides statutory notice service? Yes, is the quick answer to that. It's not your team though, is it, Louise? It's a different
That's true. That's right. It is something that we can help provide if you'd like us to. The best thing to probably suggest that you do, if you're interested in any of those services, would be to probably go online to findersinternational.co.uk. There are online inquiry forms, and there's also a chat function. You can quickly make contact, and we can tell you what's possible and give you some costs and things like that.
And there's another one from Brian. Sorry, I was just about to call you Dean, but I think it's Brian. Do participants automatically ask a plumber to drain down an unoccupied property in winter, as insurance company requirements can be so onerous? Do please pop your comments in the Q&A section to say whether you do or don't. I generally do, because many years ago I didn't, and I did have burst pipes, and we did have to claim on the firm's PI insurance because I didn't check, and the insurance had run out and I hadn't got specialist insurance. So I'm a little bit cautious on unoccupied properties in winter, or leave the heating on or drain it down, I think are the alternatives. But interesting to see if anybody else does that as a matter of course. It may be that depending on what insurance policy you get, it may be a requirement to drain down the system or to have it on at a particular minimum temperature. So you may not have a choice about whether you do or don't. Either way, it's better than having burst pipes. Although the decorator did a fabulous job on the ceiling collapsed, so they did a fabulous job of putting in a new kitchen ceiling and making it all look very modern.
I think is that all the questions? If anyone's got anything further to add, if they could very quickly note it in the chat box. Louise, if possible, if you could send kind of further information on those items you were going to follow up to me afterwards at Surrey Law Society, that would be so helpful, and then I can circulate them to everybody that's attended today. As I said, we will be sharing the recording and a feedback survey, so please do complete that. We know you're busy and it's the last thing you want to do, but it is really helpful. Thank you so much, Jane, for presenting this for us. We're really so grateful, and thank you to Louise and Finders for sponsoring. I'll assume no further questions, and we'll hopefully see you soon, and have a lovely afternoon.
Thanks very much, Helen, and thank you everybody. Thanks, Louise.
Bye-bye.
Thanks, Helen. Thanks. Bye-bye.